back to sleep. What's going on with those instructions?
Judge, if I could, initially I was hoping that the court would take up our motion for reconsideration, which was filed a week ago Monday.
Right.
And once that's done, depending on how you rule on it, I would have an objection to 2176 because in my reading of 2176, the notes set forth what is to happen or how the court is to do it when there is an alleged exception, which we are alleging here. And I think that exception has to be put into and part of the instruction. And as it reads now, I don't think there is an exception. So I think that has to be included in the instruction if the court does not grant our motion for reconsideration.
And the response is that I have not been able to complete what I wanted to do on your motion for reconsideration. I didn't get it until later last week. Didn't mean you didn't file it. I mean, I didn't get it. And I didn't have a chance to, I looked at it somewhat, but not all of it. And there's one other thing I would definitely want to check, and some other maybe. So I'm not in a position to give you a final ruling on that. I think I should instruct on it. But what you're asking for is actually exceptional language, which the instruction is not going to be frozen at the time that it's given this morning. So I think in order to acquaint the jurors with that particular case, well, I don't know, maybe I just should leave that one alone because I'm leaving the ordinance violation of the forfeiture action alone, and I can just tell them, I'll instruct them on everything at the end of the case. How do you feel about that?
Judge, I feel as though we've gotten a little bit lost in the weeds here. What the defense is alleging is an affirmative defense. If they want to raise that as an affirmative defense, they're welcome to do so. It is not the subject for a motion to dismiss. The complaint need not deflect or address every single affirmative defense. And this, so I believe there's no basis to challenge the complaint to actually get the complaint dismissed. If they wish to present a case, if they wish to raise an affirmative defense, which is that he was compliant under both of those subsections, that if he had a hunter safety permit or the certificate of completion that the second part of that, third part of that statute calls for, they can do so. But until they do that, I don't see why that should be in the jury instruction. We don't have the self-defense in the jury instruction because that's another affirmative defense, and they should raise that. And if they raise that, which they certainly will attempt to do so, then it can be in the charges at the end, or in the jury instructions at the end. So no, I don't believe that at this point there's any basis to dismiss it. I do have a brief that I could submit. I did not want to. I didn't want it to be untimely, but that does lay out why we believe it's an affirmative defense and not a subject for a motion to dismiss. In terms of the curfew violation, we're wondering how we're going to do that because that would be a 6-person jury, not a 12-person jury.
You don't think I can just pick a 12-person jury to decide it?
Well, it's a different standard of proof.
Well, that
Confusing. Anyway, I can submit this brief and send it to the defense if the court would find it helpful, but it's an affirmative defense. I mean, it's clearly what it is. I understand the defense may not want this to be addressed at trial and may not want the evidence in front of the jury, but we've met our probable cause, we've met our standard in the complaint, and it's been bound over. And now it's up to the defense if they want to try and raise this affirmative defense. We disagree that being 17 in and of itself raises an affirmative defense. The state believes he'd have to present the certificate of completion of a hunter safety permit as called for in the statute. Thank you.
Okay. Yeah, I think what I'm going to do is refrain from giving any instruction on either count 6 or count 7, and tell the jury that I'm not going to give them an instruction at this time on those. Well, I don't know if then that's probably not the best thing to do either, because then they don't know what we're talking about. What's your reaction to the claim that it's an affirmative defense?
It's not an affirmative defense. For 16 and 17-year-olds, it's not an affirmative defense. The information that I've provided to the court through the legislative history makes it clear it's an exception. It's not an affirmative defense. It is an affirmative defense for people under the age of 16. I'd agree with that 100%. But if you look at the Senate Bill 7 and the 1991 Act, in 3 different places it tells you in plain language that it does not apply. Not for hunting purposes, it does not apply, period, to 16 and 17-year-olds who possess firearms. That is, and I've provided that to the court both in the Act and in the Senate bill, Judge, and in the Legislative Reference Bureau information.
Well, I'm going to give the instruction as I've stated it. These are educational. They don't get a written copy, and they're just so they know what we're talking about when we talk about these charges. And at the close of the case, I can add whatever language is necessary, assuming that the motion is denied, which you shouldn't assume. But if the motion is denied, then I'll add the language that clears up what exactly the full scope of the charge is. But I don't think. I don't want to leave them uninstructed on the one hand, and I don't want to misinstruct them on the other, but no matter what it is exceptional from the general language of the statute.
Hey, Judge, I'm not going to argue with you about it. It makes it a strict liability offense today. If you're under 18 and you have a gun, you're guilty. And I don't think that's what the law is. So that's the problem that I have. The statute clearly lays out exceptions for that. And to just say he's under 18 and he had a gun, those are not in dispute, then he is, the way the instruction reads, there is no affirmative defense, whether it is or not, there is no defense.
No, unless he has the
No.
safety certificate. That's the last part of the statute. In Wisconsin, if you're under 16, you need to be accompanied by an adult to hunt, as long as you have hunter safety. If you're 16 and 17...
That's how you read it.
Not how we
He reads it differently.
That's how the DNR reads it. And that's how they cite it.
Yeah, okay.
So in
All
16 and 17-year-olds, you can hunt alone with a hunter safety permit, which is what the last part of that statute calls for.
Yeah, well.
And that's being completely ignored in Mr. Trofsky's argument.
Okay. I am going to give some very incomplete language to acquaint them with the fact that there's a charge on the information respecting the possession of a firearm, and that I will instruct them concerning the elements of that offense at a later point. Okay, and the same thing will happen with respect to the forfeiture action. So, any other objections or problems with the proposed instructions?
Judge, I didn't see on count 5 that you, on 1, 2, 3, and 4, you put an or you give the self-defense instruction in some level. I didn't see that for count 5, however.
Didn't they have a general instruction on self-defense?
You listed them specifically for the charges or for the counts?
They did?
That's what I saw.
Boy, it was early this morning. It says counts 1 through 5. Oh, no, that's not it. You're right. Let's see, count 5 is attempt to commit murder. That is going to have the same self-instruction as, same self-defense instruction as count. One, 3, and 4.
Very good. I just wanted to make sure that.
You were correct in your observation.
Well, you tell me when you're ready, Judge.